As talked about today in Tulane Law School, that we are fully supporting the church's teaching on the sanctity of human life, and we oppose the qualities
Others might have avoided this venue for that reason. But President Obama is not someone who stops talking to those who differ with him.
Not someone who stops talking to those who differ with him. And so, this is the President's speech on religious liberty.
Let's honor the conscience of those who disagree with abortion and draft a sensible conscience clause.
So, sounds reasonable. Shortly thereafter, though, recently, Notre Dame has joined several other Catholic institutions in the Archdiocese in suing the President. He was quoted as saying, because the need to assert the right to follow our conscience on matters such as refusing to pay for abortion-inducing drugs, contraceptives, and sterilization procedures. This is not the kind of sensible approach the President had in mind when he spoke here. So obviously, not keeping his promise, I think that's how many religious institutions talk about this. This was the executive order. This was actually signed by the President, and he mentions his commitment as part of his striking the deal with several House Democrats in passing the President's health care legislation. He signed this executive order right here to give credence to and follow the longstanding federal laws to protect conscience. They issued what they called an exemption to protect religious organizations. That's what the Health and Human Services mandate alleges. But if, upon further review, the exemption is really one of the most narrow constructions of religion that there is, much more so than we've seen in the past. The government has a four-part test in order for a religious institution to qualify for this exemption. First, it must have inculcation of religious values as its purpose. Number two, it must primarily hire those who share its religious tenets. Three, it must primarily serve those who share its religious tenets. That's presumably excluding religious organizations that serve the common good. I know there are many Catholic and many other religious organizations that have offshoots of that would not qualify for this exemption. And finally, it must be a church, convention, or association of churches, integrated auxiliary or religious order. That's defined by the IRS tax code. So, obviously, after many religious folks were looking at the accommodation and they were concerned about this government-sponsored four-part stringent test to qualify, and the government now is in the business of defining what the religion is, the President, to address those concerns, issued what he called an accommodation. And he and the HHS Secretary, whose office, who actually is Catholic, Kathleen Sebelius, I believe is her name, addressed reporters and the public to talk about this accommodation.
Now, as we move to implement this rule, however, we've been mindful that there's another principle at stake here, and that's the principle of religious liberty, an inalienable right that's enshrined in our Constitution. As a citizen and as a Christian, I cherish this right. In fact, my first job in Chicago was working with Catholic parishes in poor neighborhoods, and my salary was funded by a grant from an arm of the Catholic Church. And I saw that local churches often did more good for a community than a government program ever could. So I know how important the work that faith-based organizations do and how much impact they can have in their communities. I also know that some religious institutions, particularly those affiliated with the Catholic Church, have a religious objection to directly providing insurance that covers contraceptive services for their employees. And that's why we originally exempted all churches from this requirement, an exemption, by the way, that 8 states didn't already have. And that's why, from the very beginning of this process, I spoke directly to various Catholic officials. And I promised that before finalizing the rule as it applied to them, we would spend the next year working with institutions like Catholic hospitals and Catholic universities to find an equitable solution that protects religious liberty and ensures that every woman has access to the care that she needs. Now, after the many genuine concerns that have been raised over the last few weeks, as well as, frankly, the more cynical desire on the part of some to make this into a political football, it became clear that spending months hammering out a solution was not going to be an option, that we needed to move this faster. So last week I directed the Department of Health and Human Services to speed up the process that had already been envisioned. We weren't going to spend a year doing this, we're going to spend a week or two doing this. Today we've reached a decision on how to move forward. Under the rule, women will still have access to free preventive care that includes contraceptive services, no matter where they work. So that core principle remains. But if a woman's employer is a charity or a hospital that has a religious objection to providing contraceptive services as part of their health plan, the insurance company, not the hospital, not the charity, will be required to reach out and offer the woman contraceptive care free of charge, without copays and without hassles. The result will be that religious organizations won't have to pay for these services, and no religious institution will have to provide these services directly. Let me repeat, these employers will not have to pay for or provide contraceptive services. But women who work at these institutions will have access to free contraceptive services just like other women. And they'll no longer have to pay hundreds of dollars a year that could go towards paying the rent or buying groceries. Now, I've been confident from the start that we could work out a sensible approach here, just as I promised. I understand some folks in Washington may want to treat this as another political wedge issue, but it shouldn't be. I certainly never saw it that way. This is an issue where people of goodwill on both sides of the debate have been sorted through some very complicated questions to find a solution that works for everyone. With today's announcement, we've done that. Religious liberty will be protected, and a law that requires free preventive care will not discriminate against women. And we live in a pluralistic society where we're not going to agree on every single issue or share every belief. That doesn't mean that we have to choose between individual liberty and basic fairness for all Americans. We are unique among nations for having been founded upon both these principles, and our obligation as citizens is to carry them forward. I have complete faith that we can do that. Thank you very much, everybody.
No questions. Judge Witten, can you hear back there? See if I can tell. We're fine. Okay. All right. I don't know if many of you have seen this, and probably some of our lawyers have. Recently, the United States Supreme Court issued an opinion dealing right squarely with the issue of religious liberty, and it involved a Lutheran church terminating one of its ministers. The plaintiff in the case was a woman by the name of Cheryl Parrish. She was a fourth grade teacher. She was an ordained minister in the Lutheran church, but she was also a teacher, and many of her duties included secular activities. And the government, similar to the position they're taking in their HHS mandate, had a very narrow definition of religion. And at the time, she had suffered from narcolepsy and had to take a leave of absence from her work. Her position was no longer available for her, and they brought her before, I believe it was the Synod, which is the governing body of the Lutheran Church, and they have a religious tenet. One of their core beliefs is that any dispute among a minister in the church is to remain within the church, and it violated their core principles to take any type of legal action against the church. Well, when it was made known to her that her position was no longer going to be available, she did what all good Americans did. She's going to call her lawyer. And she called her lawyer, and she had threatened to file a lawsuit against him. Well, that was a violation of the church's tenet, and they terminated her. So she immediately turned around and sued the church, saying that the church had violated the Americans with Disabilities Act, and the administration felt that her claim had merit, and the Equal Employment Opportunity Commission joined with her in suing this Hosanna Tabor church. Very interesting the position that the government attorneys took in the matter. The United States Supreme Court had never actually recognized what they called a ministerial exception. And the ministerial exception requires, or says, and it had been in the lower circuits, but never been addressed or adopted by the United States Supreme Court. And it says that a church cannot be sued, or any adverse action could not be taken if it involved a religious matter such as this, in matters of the church. And there was a ministerial exception to the application of this Americans with Disabilities Act. Well, the government started snooping around, and they argued the position that, first of all, a church is no different than a social organization or a labor union and should not be subject to the religious clauses of the First Amendment, free exercise, and the Establishment Clause, and that instead her belief laid in an implicit right of association that is guaranteed by the First Amendment, and they argued against the Supreme Court recognizing this ministerial exception. And the Supreme Court issued in their opinion, said such a position offered by the government was untenable and even remarkable. They even cited, there's an old case, I say old, it was I think in the 80s, involving, many our lawyers here maybe studied in law school, it's a peyote case where these Native Americans, as part of their sacrament, they would ingest peyote. And they were terminated after they had tested positive, and they were denied benefits when they applied for unemployment compensation. And the United States Supreme Court then said that this was a law of general applicability. It was neutral on its face, so it didn't violate the religious clauses. And that's what they were trying to argue. And the language of the court, the opinion, they even said it was kind of, I think it was kind of a backhanded rebuke to the government. The church's selection of its ministers is unlike an individual's ingestion of peyote. I mean, that's the argument that they were making. And they also narrowly defined minister under the ministerial exception, and you'll hear a brief audio in a second, where the government tries to say that her duties, she may have been an ordained minister, but she had many secular duties, and we at least should be allowed to argue and have that brought before the court. Now, the lower court dismissed it and said the ministerial exception applied. The Sixth Circuit Court of Appeals said, no, you're right. She may have had some secular duties, so maybe that the religious clauses shouldn't apply. But the United States Supreme Court took the case up, and they slapped down the government's argument that she must perform exclusively religious functions. They rejected that position as extreme. But this is very interesting. This is Justice Scalia talking about religious autonomy in the case. And if this case, this HHS mandate comes before it, I have a hard time believing that it wouldn't meet the same fate.
She was fired simply for asking for a hearing.
I understand that, but once you start to litigate these cases,
I think your point is that it's none of the business of the government to decide what the substantial interest of the church is.
that's one of my points, maybe the most important of my points.
So Justice Kennedy was trying to say, you even terminated her before you even got to let her make her argument that she had secular duties and she was a minister. You didn't even let her litigate it. Scalia was like, that's a matter that should be handled. You're mucking around in the church's business. What authority does the government have? A very interesting point there. This is another interesting point he made, and when he refers to the government's position as extraordinary.
Ms. Kruger?
Mr. Chief Justice, and may it please the Court.
Freedom
of religious communities to come together to express and share religious belief is a fundamental constitutional right, but it's a right that must also accommodate important governmental interests in securing the public welfare. Congress has not unconstitutionally infringed petitioners' freedom in this case by making it illegal for it to fire a fourth-grade teacher in retaliation for asserting her statutory rights.
Is the position of the United States that there is a ministerial exception or that there is not a ministerial exception?
Mr. Chief Justice, if the ministerial exception is understood as a First Amendment doctrine that governs the adjudication of disputes between certain employees and their employers, we agree that that First Amendment doctrine exists.
Nothing to do with respect to the ministers. In other words, is there a ministerial exception distinct from the right of association under the First Amendment?
We think that the ministerial exception is one that incorporates the right of association as well as the rights under the religion clauses.
Is there anything special about the fact that the people involved in this case are part of a religious organization?
We think that the analysis is one that the Court has elaborated in other cases involving similar claims to autonomy, non-interference.
Is that a no? You say it's similar to other cases, expressive associations. A group of people who are interested in labor rights have expressive associations. Is the issue we're talking about here, in the view of the United States, any different than any other group of people who get together for an expressive right?
We think the basic contours of the inquiry are not different. We think how the inquiry plays out in particular cases may be.
It's extraordinary.
It's
extraordinary. We're talking here about the Free Exercise Clause and about the Establishment Clause, and you say they have no special application?
The contours, but the inquiry that the Court has set out in its expressive associations, we think, translate quite well to analyzing the claim that Petitioner has made here, and for this reason. We don't think that the job duties of a particular religious employee in an organization are relevant to the inquiry.
There's nothing in the Constitution that explicitly prohibits the government from mucking around in a labor organization. Now, yes, you can, by an extension of First Amendment rights, derive such a, but there, black on white in the text of the Constitution are special protections for religion, and you say that makes no difference.
Well, Justice Scalia.
Pretty credible. Obviously, he was concerned with it. He wasn't the only one. In fact, Justice Sotomayor, anybody who doesn't follow the court, she's about as ideologically far away from Justice Scalia as you could get. But here's her response to the government's position on that matter.
Do you believe, Ms. Kruger, that a church has a right that's grounded in the Free Exercise Clause and or the Establishment Clause to institutional autonomy with respect to its employees?
We don't see that line of church autonomy principles in the Religion Clause jurisprudence as such. We see it as a question of freedom of association. We think that this case is perhaps one of the cases.
So this is to go back to Justice Scalia's question, because I too find that amazing, that you think that neither the Free Exercise Clause nor the Establishment Clause has anything to say about a church's relationship with its own employees.
We think that this is one of the cases that Employment Division versus Smith may have been referring to when it referred to free association claims that are reinforced by free exercise concerns.
So anyway, that should tell you you're in trouble when you have Justice Sotomayor and Scalia on the same side against you. This is Judge Roberts, Chief Justice Roberts. This is what he said.
I'm just asking you to assume with me for a moment that there is a categorical exception, and to tell me who you think counts as a minister and why the woman in this case does not.
Well, in our view, if that was the test, then we would say that the Court of Appeals was correct in holding that she was not a minister, and the principal reason is she carries out such important secular functions in addition to her religious duties.
I'm sorry to interrupt you, but that can't be the test. The Pope is a head of state carrying out secular functions, right? Those are important. So he's not a minister?
So even the gallery, busted in laughter like that. I mean, it's kind of laughable. But, the basic legal challenges will be obviously under the religion clauses to this HHS mandate. It will be the religious clauses, free exercise, and the establishment religion. Also, after that Odie case, Congress passed what they call RFRA, Religious Freedom Reformation Act, and although it's been struck down as unconstitutional as applied to state and local governments, it's still in effect to prohibit federal action that infringes on religious conduct. And the significance of RFRA is that it substantially increases or augments the definition of religion, and more so even than the government's position in this, under the Constitution. So the United States Supreme Court has said this test is the most demanding test under the constitutional law. The statute must be in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling government interest. Not many statutes survive that type of analysis. This is an interesting position. I don't know if maybe some of our members have seen this because I put it on our Facebook page, but the HHS Secretary Kathleen Sebelius was brought before a congressional subcommittee, and was specifically asked what legal authority that the administration sought, or how they justified the action on the HHS mandate. And this is Congressman Gowdy. He's a Republican from South Carolina. This was, I think, around April of 2012.
You said, and I quote, "This decision was made after very careful consideration, including the important concerns some have raised about religious liberty. I believe the proposal strikes the appropriate balance between respecting religious freedom and increasing access to important preventive services. There are only 3 balancing tests that I am aware of when it comes to matters of constitutional significance. There is the rational basis balancing test for economic legislation. There is the intermediate or mid-level scrutiny for gender-related constitutional issues. And then there is the heightened or strict scrutiny when fundamental rights are involved. And given the fact that I am sure you can see that religious liberty is a fundamental right, which of those 3 constitutional balancing tests were you making reference to when you said you balanced things?"
Congressman, I'm not a lawyer, and I don't pretend to understand the nuances of the constitutional balancing tests.
But you
I
would agree
assume you're talking about the preventive services.
You would agree it's a legal issue, right? I mean, we're going to wind up in this. Last time I was at the Supreme Court, I think you and I were there the same day during the oral argument. This mandate is going to wind up in the Supreme Court. To me, it is. We can talk about the politics all we want to. I want to talk about the law. I want to talk about balancing religious liberty with whatever else you think it's appropriate to balance it with, because you use the word balance. Which of those 3 tests is the appropriate test for us to use when considering religious liberty?
Again, Congressman, I am not going to wade into constitutional law. I'm talking about the fact that we are implementing the law that was passed by the Congress, signed by the President, which directed our department to develop a package of preventive health services for women. We have done just that with the advice of the Institute of Medicine and promulgated that rule.
Do you agree with me that government cannot force certain religious beliefs on its citizens?
Yes, sir.
And why can they not do that?
Why can government not force religious beliefs?
What's the basis of that?
The separation of church and state.
Well, the Constitution, right? The First Amendment. Can government decide which religious beliefs are acceptable and not acceptable?
No, sir.
And why can they not do that?
It's part of our Constitution.
It's a legal analysis. I mean, for me, this is not a political analysis. It is a legal analysis. So, before this rule was promulgated, did you read any of the Supreme Court cases on religious liberty?
I did not.
You would agree with me that our society has a compelling interest, not just an important interest, a compelling interest in having an educated citizenry, right?
Yes, sir.
Right. So when a state said you have to send your children to school until a certain age, and a religious group objected because they did not want to send their children to school until that certain age, do you know who won? It went to the Supreme Court.
I do not.
The religious group won. I think the state has a compelling interest in banning animal sacrifice. Whether it's compelling or just important is irrelevant for purposes of this discussion. When a state banned the practice of animal sacrifice and a religious group objected, it went to the Supreme Court. Do you know who won that?
I do not, sir.
The religious group won. I think the state has an important interest in having license tags on automobiles so law enforcement can know who they're dealing with. When a religious group objected to having a certain license tag on their cars, it went to the Supreme Court. Do you know who won?
I do not.
The religious group won. And most recently, I happen to think government has a compelling interest in avoiding gender discrimination. But this administration took to the Supreme Court a case Hosanna Tabor, where a religious group wanted to decide who its teachers were, even if it meant gender discrimination, it was a 9-0 opinion in favor of religious liberty. So when you say you balance things, can you understand why I might be seeking a constitutional balancing instead of any other kind?
I do, sir, and I defer to our lawyers to give me good advice on the Constitution. I do not pretend to be a constitutional lawyer. No.
Is there a legal memo that you relied on? At least when
I relied on discussions.
At least when Attorney General Holder made his recess appointments, there was a legal memo that he relied on. Is there one you can share with
Attorney
us?
General Holder clearly runs the Justice Department and lives in a world of legal memos.
Do you have Attorney
General?
I'm sorry,
the gentleman's time has.
Saved by the bell. It's kind of scary. These people are formulating policy in the third of religion. And it seems like they have elementary education when it comes to the Constitution. Here's the separation of church and state in the Constitution. It's actually mentioned in a letter Thomas Jefferson wrote to the Denver Baptist, Justice Black incorporated into one of his opinions in the Everson case. But they're always, that's their traditional response. So back to the main event. A little bit about our guest. This is all prelude. I apologize for the wait, though, but I want to kind of set the stage legally, kind of what was going on. And the Archbishop, who's maybe, and we were talking about this earlier, the first Archbishop in the history of this diocese to have a law degree, which is quite impressive. Briefly, he was born in New Orleans, Louisiana, on March 27th, 1949. He was succeeded Bishop 4 years. Oh, excuse me. I'm sorry. He went to Dunsell High School in New Orleans. He attended and also received his BA from Georgetown University in Washington. He went to Tulane University School of Law, where he obtained his Juris Doctorate. See, the Priors are here. I believe their son actually got his JD from there as well. Also went to Notre Dame Seminary and Catholic University of America, where he obtained his JCL. He is an ordained priest of the Archdiocese of New Orleans, 1978. He served as the associate pastor and pastor at various parishes in the Archdiocese of New Orleans for 12 years. He taught canon law as an adjunct member for 10 years at Notre Dame Seminary in New Orleans. He was appointed Chancellor of the Archdiocese of New Orleans in 1992. He was appointed Vicar General of the Archdiocese of New Orleans in 1996. He was appointed Bishop of Biloxi in 2001. And Mobile got very lucky, and he was appointed the Archbishop here in 2008. We're looking forward to your comments tonight and putting a human touch and face on these most important weighty constitutional issues and matters of conscience. Thank you for joining us. Please join me in welcoming.
I want to thank Matt for the invitation and Tom Walsh for the invitation to be here. It's an honor and a pleasure to be here with you all. Please excuse me if I leave my cell phone here. It's just so that I can look and see what time it is as I speak. Do you know, by the way, what it means when an archbishop puts his watch or cell phone here to look at the time? Absolutely nothing. But if it gives you hope that I will end timely, I'm so happy for you. Anyhow, that introduction certainly put a context to the comments that I have here this evening. You know, we as Americans have consistently, not perfectly, but consistently respected religious liberty in our country. From the very beginning of our establishment as a country, we have been a diverse people of different religions, beliefs, faiths. And we have said to one another, I will not force you to do anything against what you believe, and you will not force me to do anything against what I believe. And we have been fairly consistent in respecting the principle of religious liberty. Even in the most traumatic moments of our country's history, when we have been at total war And when every young man turned 18, we put a gun in his hand and said, now go fight the enemy and kill the enemy, and perhaps you will be killed in the process, but you will serve. Even in those moments, as painful as they were, if a young man said, but in my church, we are not allowed to fight, then we said, then you're exempt. We will not force you to do something against what you believe. And imagine how difficult in those moments it would be. When everyone else's son, everyone else's brother, everyone else's father is going off to fight, to say, but we will exempt you because of your religious beliefs. That really says something about how ingrained religious liberty is in our American character. Now, when the Constitution was first written, quickly 10 amendments were added to the Constitution, the Bill of Rights. It is not a coincidence that the first of those 10 amendments was religious liberty. And when the Constitution was written and established this new government, and the Constitution said, now this is how the government is going to operate, they quickly added those 10 amendments that said, and this government must respect these rights. And the first, religious liberty, why would that be first? Well, the writers knew that any country that would coerce its citizens to act against what they believe would not long maintain its other liberties. And how did they know that? They had seen it. They had seen it in some of the countries that they came from in Europe, where people could be arrested, fined, even put to death for what they believed. And they wanted this new country to have religious liberty. You know, it is good to remember that many of the first colonists that came from Europe to North America came seeking religious liberty. Roger Williams, and William Penn, and John Carroll came from England and to these colonies because Congregationalists, Quakers, Catholics did not have religious liberty in England. So they came seeking it, and so did others. But today is a troubling moment for our country because religious liberty is really under assault, both from the right and the left in our country. And there are many examples I could give. But let me just offer a few. Recently in Connecticut, a bill was introduced in the state legislature, almost passed, that would have forced Catholic parishes to be restructured according to a congregational model. The stated purpose of the bill was, quote, to revise the corporate governance provisions applicable to the Roman Catholic Church, and would just make the bishop and the pastor an ex officio member of the board that would run the parishes in order to take the bishop out of the governance of a hierarchical church. In Boston, San Francisco, District of Columbia, State of Illinois, they have coerced Catholic charities out of providing ministries of adoption and foster care by revoking their licenses because these charities refuse to place children with cohabitating, unmarried, or same-sex couples. The Health and Human Services contracts for migration services of victims for human trafficking have disqualified Catholic Relief Services because they changed the requirements for those who would serve in this capacity, requiring that they offer now a full array of reproductive services, meaning that Catholic Relief Services would have to provide contraceptives and abortion services for those involved in victims of human trafficking. By the way, that rule seems to be now changed because, quite frankly, CRS, Catholic Relief Services, does such an outstanding job that it was hard to replace them. New York City enacted a rule recently which bars churches from renting school facilities for worship services, even though any other non-religious group may rent the same schools for any other purpose. Now, this doesn't affect Catholic churches, but it does affect smaller churches that would look for a place to have worship. Alabama, the refusal to exempt church ministries from our recent immigration law. The state law criminalizes any activity which would, quote, encourage, unquote, an illegal immigrant to reside in Alabama with, quote, reckless disregard for the immigration status of that person. So what is encourage someone to reside in Alabama? Would allowing illegal immigrants to come to Sunday school, attend AA meetings, give them food, clothing, help them with rent, allow them to register in a Catholic school, give them a ride to church on Sunday or to the doctor when they needed to go to the doctor, allowing them to come to church. Are these encouraging illegal immigrants? And that's why bishops, Episcopal, Methodist, Catholic, challenged the law. And there have been some assurance by some state leaders that this law was not intended and was not written to cover churches. Well, it's not what was intended, it was what the law says. And state officials do not enforce the law, local sheriffs do. And so, the State House put into the law an amendment that said, quote, nothing in this act would prevent a church or other bona fide religious organization or an agent or officer of such a church or denomination from ministering to or providing material goods or services to all individuals regardless of immigration status. Basically, we're not trying to tell the churches who they can baptize or who they can allow into the church. Sadly, the Senate version did not have that provision, and that was the version which is the law of our state. But the regulation which is receiving the most attention is, of course, the Health and Human Services mandate, providing for drugs and medical procedures which we as Catholics consider to be immoral. The mandate forces almost every employer to provide contraception, sterilization, abortifacient drugs for employees. And there's no exception to this new regulation except that which Matt just explained, that the employee has to be hired for a church ministry that primarily is for the inculcation of faith, and for an employer that primarily hires and serves only members of his church. Why would church leaders in particular, and people of faith, be so concerned about all this? Well, we see what's happening elsewhere in the English-speaking world. We see in our growing secularization a real assault on religious freedom, religious liberty elsewhere. Look to Canada. And we can see where we're going as the United States when we look at other English-speaking countries, or at least where we may be going. Canada has a Canadian Human Rights Act, which states that it is discriminatory to communicate by phone or internet any material, quote, that is likely to expose a person or persons to hatred or contempt. 5 years ago, the Ontario Human Rights Commission fined a printer for declining to print homosexually themed stationery. In Saskatchewan, their rights tribunal fined a gentleman thousands of dollars for quoting a Bible verse in a letter to a newspaper. And a mayor in Ontario was fined $10,000 plus interest for declining to proclaim a gay pride day. And nor have Catholic bishops in Canada been spared. One Catholic bishop an outspoken defender of sanctity of life and marriage, was brought before a Human Rights Commission because he was upholding publicly Catholic moral teaching. The complaint was ultimately withdrawn, not by the government, but by the complainant, but the bishop incurred rather hefty legal costs in defending himself. Now, Ontario has a bill that will force Catholic schools in that province to have gay pride clubs. And once this law goes into effect, the Canadian Civil Liberties Association has made it very clear that they will do everything in their power to make sure that Catholic teaching on sexual morality is removed from Catholic schools, because such teaching would create a situation of making gay students feel, quote, unsafe, shameful, and humiliated. As one advocate of this policy said, quote, when doctrine or policy is being used in a discriminatory fashion, including creating a poisoned environment for vulnerable young people, then yes, it is challengeable, and they intend to remove Catholic teaching from Catholic schools, because basically there are those who view it as hate speech. In Ireland, police have confirmed that they're prepared to file and forward it to the Director of Public Prosecutions against an Irish bishop, Bishop Boyce, because in his homily he stated one day, quote, that Ireland is being attacked from outside by the arrows of a secular and godless culture. The crime which the bishop is accused of is incitement to hatred of dissidents, outsiders, secularists, all who are perfectly good citizens within the meaning of civil law. In Sweden, I know I said I limit myself to the English-speaking countries, but just as one example, rather extreme, a Lutheran pastor was sentenced to a month in prison for preaching a sermon in church proscribing homosexual conduct. That, fortunately, was reversed on appeal. But we see what is happening elsewhere in the world as the world becomes more secular and religious liberty under assault. And this mandate then causes great concern because of the context within which religious liberty now is facing its challenges, and because of the mandate itself. Basically, this mandate separates churches from its ministries by requiring these drugs and procedures which the church considers to be immoral, and being only allowed to exercise the religious liberty of objecting to those procedures in that extremely narrowly defined four-part test, as you heard. The inculcation of religious values is the purpose of the organization. The organization primarily employs persons who share the religious tenets of the organization. The organization primarily serves persons who share the religious tenets of the organization, and the organization is a nonprofit organization. If we really had to adhere to that definition, it is very possible that Jesus would not qualify as a religious leader. Since there is some evidence that he ministered to the Samaritan woman at the well, the Phoenician woman whose daughter was sick, and the Roman centurion, none of whom belonged to his religious organization. But if this policy then is put into effect, church ministries, and I'll limit myself to the Catholics, although Dr. Foley would certainly be able to speak on behalf of a Baptist ministry. Our Catholic schools, we hire non-Catholics, we serve non-Catholics. Little Sisters of the Poor allow non-Catholics to be residents there and care for them. Catholic social services, most of the people that come to our social service centers in the Archdiocese of Mobile are not Catholic. St. Mary's Home, we accept young people regardless of religion. Allen Memorial, Again, the list could go on. Our Catholic schools, colleges, social service centers, all these ministries would be considered by the government as not being religious. As we just heard, this regulation really is consistent with the administration's efforts to narrowly define what is a religious organization entitled to religious liberty. In the Hosanna Tabor Evangelical Lutheran Church, the school case we just heard, the administration was arguing really that freedom of religion religious liberty is really to be narrowly defined as freedom of worship, not the free exercise of religion. And there is a difference. The First Amendment does not guarantee freedom of worship. It guarantees free exercise of religion. That not only do we as believers have a right to go into our churches, synagogues, temples, mosques, and worship, but we have a right then to leave there and go practice our religion out in the public to serve the common good. I remember, not to say that there's too much of a similarity here between the United States and the Soviet Union, but I'm old enough to remember during the times of the Soviet Union when they said, we have freedom of worship here in Russia. Anyone can go in the church. See, the church is right there. But they did not have freedom of religion. And we as Americans are guaranteed the right to exercise our religion. And that's what makes this new regulation so insidious. Because it tells us as believers that our ministries of schools, colleges, hospitals, nursing home, fraternal organization, media ministries, social service centers, and other charities are separate from the churches and its members. We as followers of Jesus Christ believe that we must serve others. It is the Lord himself who told us love of God and love of neighbor cannot be separated, that they are integral to respecting each other and being his followers. We are compelled by the love of Christ not only to worship God, but then to live our faith by offering our church ministries. So the ministries of the church cannot be separated from worship because they flow from worship. They're founded upon our faith to fulfill the two great commandments of Christ. And this is the crux of the issue. The President's administration seeks to coerce me as Archbishop of Mobile to speak against what I believe. This mandate forces me to say to our church employees that I am offering you drugs, medical procedures, which I morally object to, that our church teaches are evil. But here they are. This is evil, and this is how you do it. And then the government seeks to coerce me to act against what I believe by paying for these drugs and services. And the only way that this could be avoided then, basically, would be to ignore our Christian duty to reach out to all of God's children, or to perhaps curtail or even close our church ministries, or to keep our church ministries open, but operate in a way which we consider to be immoral. As was alluded to in that presentation that summed up all this constitutional area of law, a very complex one, a very long one, there was this previous Supreme Court test of religious liberty and when the government could interfere or regulate or restrict. And perhaps the best was the Sherbert versus Verna case, 1963, in which a Seventh-day Adventist a woman who became a Seventh-day Adventist could not work on Saturday. For this, she quit her job, which required Saturday work, and couldn't find another work. She applied for unemployment. She was refused because she was told that she could find employment. She just had to work on Saturday. But she said that was against what she believed. And so went to the Supreme Court. The Supreme Court sided with her and issued that test that stood for a number of years, that a challenged law must serve not only an important public purpose, but a genuinely compelling one. That the law is well tailored to achieve that purpose, and the purpose could not have been achieved by some less burdensome method. That was the test in that case. It was upheld and reiterated in 1972 in the Wisconsin versus Yoga case about the Amish who were required by state law for their children to go to school through 10th grade. It is against Amish belief for children to be educated beyond 8th grade because they feel that is education would be inappropriate for their simple way of life. And they say we will educate them further by vocational training, basically to become farmers. We do not want, and in fact, religiously object to further education. Again, it went to the Supreme Court. The Amish won on that threefold test: compelling state interest, well tailored to achieve that purpose, and there's no other less burdensome way to do it. Again, in the peyote case that we heard, again, that was upheld when the government said, well, these two Native Americans were working for a drug rehabilitation program. They were fired because when they worshiped, they ingested a hallucinogenic drug. They applied for unemployment. They were turned down because they said you were fired for misconduct. They said, no, we're fired for religious reasons. And that went to the Supreme Court. And again, that case, those 3 points were again upheld. This was fine until in 1990. The law changed when, with the peyote case, I take that back, excuse me, they were not upheld on the peyote case. And Justice Scalia wrote the law saying, upholding the decision against the two employees. Because Justice Scalia said, general laws that do not discriminate against any particular religious practice do not violate the Constitution. He wrote, quote, values that are protected against government interference through enshrinement in the Bill of Rights are not thereby banished from the political process. He readily admitted in his decision that, quote, leaving accommodation to the political process will place at a relatively disadvantage those religious practices that are not widely engaged in, but that is unavoidable consequences of democratic government, which must be preferred to a system in which each conscience is a law unto itself. So in that peyote case, which the government appealed to recently in the Hosanna case, Scalia wrote that values that are protected against government interference through enshrinement in the Bill of Rights are not thereby banished from the political process. I would submit to you that the reason why the writers put religious liberty into the Bill of Rights was to keep it out of the political process. You know, there are many goods in our society. It is good that people practice being a veterinarian. It is good that people practice being an orthodontist. It's good that people practice being an architect. But these are not enshrined in the Bill of Rights. And therefore, they are subject to the political process and to be regulated through the political process. But in the Bill of Rights, religious liberty is put into there in order to keep it out of the political process to the extent possible, so that this right of religious liberty is not subject to the majority rule of the moment or subject to whoever might be in power at the moment. Justice O'Connor in that peyote case dissented, and she wrote this: the compelling interest test that had been the test of time after 1990 in this peyote case. The compelling interest test effectuates the First Amendment's command that religious liberty is an independent liberty, and that it occupies a preferred position, and that the court will not permit encroachments upon this liberty, whether direct or indirect, unless required by clear and compelling government interest of the highest order. Her opinion was not accepted by the Supreme Court. She went on, only an especially important government interest pursued by narrowly tailored means can justify exacting a sacrifice of First Amendment freedoms as the price for an equal share of rights, benefits, and privileges enjoyed by other citizens. And again, one of the dissenting justices, Blackmun, reminded his brethren that, quote, it is not the state's broad interest in fighting critical war on drugs that must be weighed against the respondent's claim, but the state's narrow interest in refusing to make an exception for the religious ceremonial use of peyote, unquote. From this perspective, the dissenters concluded on the court that virtually nothing is lost by granting the exception, especially since the state could present no evidence of harm resorting from sacramental peyote use, and the dissenters pointed out that both the United States and 23 states exempt sacramental use of peyote from criminal prosecutions without reported problems. But following that 1990 decision, religious liberty became, before the Supreme Court, more and more involved in the political process. And the problem with this is the more we put religious liberty within the political process, the more that we will give to others the impression, and inevitably to ourselves, that religious liberty comes from the political process. But it doesn't. It comes from a fundamental liberty enshrined in the Bill of Rights. The Religious Freedom Restoration Act was passed 3 years later, in 1993, which enshrined in statutory law, at least on the federal level, what had been settled law by the Supreme Court up to 1990. Again, the compelling state interest, narrowly tailored and least burdensome method. I'd offer 3 points. First, if religious freedom is subject to the political process, it will be increasingly questioned, discounted, and curtailed in our ever-secularized society. We have only to look at other countries to see this. The Pew Research Center recently, in their study, said that 70% of the people in the world live in countries where religious freedom is highly or very highly restricted, either because of governmental actions or private actors. Interestingly, Europe had the highest proportion of nations where social hostilities against religious freedom is rising. According to the Pew Research Center, the United Kingdom is now in the same category with Saudi Arabia and Iran on high social hostilities. French governmental actions now has it ranked ahead of Cuba in that category. And there are those who are publicly now saying that if or when England accepts same-sex marriage, that dissenters need to be pursued by the law. Second, we need to remember religious liberty does not have a long history. Religious freedom in Europe has existed only basically for the past 200 years. That's not a long time in human history. In England, for 2 centuries, it was a crime to be a Catholic priest, punishable by death. The last execution was as late as 1680. Religious liberty for Catholics didn't come until much later. French history, even as in the 1790s, showed great antipathy to religious liberty. when a temple is erected, a pagan temple is erected in Notre Dame Cathedral, the goddess of wisdom was worshipped there, and the government redid the calendar to have 10-day weeks instead of 7 so that people would forget what day was Sunday. And the third, words from others caution us into the consequences of an absence of religious liberty from life, and why we need, in the life of our nation, to maintain it. George Washington's farewell address. Reason and experience both forbid us to expect that national morality can be retained without religion. John Adams. Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other. John Kennedy, in his inaugural address, spoke of the rights for which our forebears fought, namely, the belief that the rights of man come not from the generosity of the state, but from the hand of God. And Alexis de Tocqueville. Not until I went to the churches in America and heard her pulpits flame with righteousness did I understand the secret of her genius and power. America is great because America is good. If America ever ceases to be good, America will cease to be great. And the religious aspect of the country was the first thing that struck my attention. I do not know whether all Americans have a sincere faith in their religion. Who can search the human heart? But I am certain that they hold it to be indispensable to the maintenance of Republican institutions. I would say for the sake of our nation, we cannot fail to demand religious liberty. And we need to make sure that unless there is a compelling state interest, it remains out of the political process. The Declaration of Independence made it clear that our fundamental rights do not come from a political process. We hold these truths to be self-evident, that all men are created equal and are endowed by their Creator with certain unalienable rights. That's what we said to the King of England when we declared independence. Your Highness, our rights do not come from you, nor from Parliament, nor from a court. They come from God. And it's important that we remember that our right to religious liberty was not given to us by any government, nor does any government have a right to take it from us. Thank you. I'm open to any questions. I may not have any answers, but I'm open to any questions.
Archbishop, I know this sort of asks you to speculate a little bit, but I'm sure the U.S. Conference of Bishops have anticipated that if the mandate is not found unconstitutional and if we don't have a new president, what's going to be the religious community's next move?
This is going to be very painful. First of all, the accommodation which has been offered, which, by the way, is not law. It's just been proposed for public comment. I think some people have the impression that the accommodation is, that the original mandate has been amended with the accommodation. That is not true. The original mandate stands without change, but an accommodation has been proposed for public comment. So even the accommodation that we heard mentioned has not been enacted. That is totally unacceptable because, as was explained in the clip, the accommodation would say that the drugs, the medical procedures, the abortifacient drugs, that religious organizations that would object to them would not have to pay for them, but the insurance companies would offer them free, right, and that employees would not have to pay even a copay for them. Now, the best image I can use is this. Suppose you went to buy a car, and the dealer said, I'll sell you the car for $20,000. And you said, fine. And the dealer said, and I'll throw in a satellite radio for $1,000 more. And you said, no, I don't want the satellite radio. The dealer said, okay, I'll tell you what. I'll sell you the car for $21,000 and the radio's free. If you didn't catch that, don't go buy a car. But the insurance companies are not going to provide this for free. They're in it to make money. And so all that will mean is that our premiums on everything else will be raised. Plus, most dioceses are self-insured. So even that accommodation won't help us because we're the insurer. But then what happens if nothing changes and this law goes into effect next year, next February? Then we will be forced to be in a situation choosing between helping not helping the poor, or helping the poor and doing so in a way that we feel is immoral. That is a terrible position to have to face, and I don't know how we will handle it. But that's the reality of what we're facing. And there are those who suspect that this is just the first mandate. If in contraception is something that is very widely practiced and would not be controversial, but if this can be forced, well, why not force Catholic hospitals to have abortions? Why not force euthanasia? And the list could go on. So this may be only the first mandate. We're very concerned.
Maybe the whole house of cards will come tumbling down on Monday when the Supreme Court issues that. If they do,
we see where all this will go. Yes?
Why would you not continue as you have been doing, no matter what the law says?
Continue.
I'm a sponsor.
You mean to ignore the law?
Yes. Based on your beliefs.
No, we could. We will be subject to extraordinarily high fines, which will bankrupt us. So it would
pay them. You think the government's going to put all of the Catholic archbishops in jail?
They wouldn't put us in jail. They just seize all the assets, which they can do. So then we wouldn't have any of the material assets to serve the poor.
They would get away with it. They would not get away with it.
Well, so we have, this is a very, very troubling situation, to put it mildly.
Historically, there have been a number of situations where people have defied the law and done what they believe.
Yes, there have been. Yes. Anything else? I'll say, I think there's a big issue here that goes beyond this mandate, beyond who may be in power in Washington at any particular time, and it's really the secularization of our society that therefore discounts religious liberty. And that's something that is very problematic for us as a free society. Our past two popes of the Catholic Church, our current Pope, Pope Benedict, and before him, Pope John Paul II, one Pope Benedict from Germany, the other from Poland, they both lived in societies where their countries were taken over by the Nazis and the communists. And as differing as these two systems may be, they do share this. They told the people that your basic dignity, your basic rights, come from the state. Your dignity comes, the Nazi says, because you're a member of the Reich. And the communists told the people, your basic dignity comes because you're a worker for the state. And Pope John Paul II, growing up in Poland, being a bishop in Poland, kept preaching to the people that this is a lie, that our dignity and our fundamental rights come from God, not the state. Pope Benedict has continued that message. It's very interesting. After communism fell, Pope John Paul II increasingly directed that message to the democratic countries of the West, warning us in the West that we may be falling into that same error. One of the finest speeches I could recommend to you was a speech that Pope Benedict gave before Parliament a couple of years ago. He, the first Pope invited for a state visit to England, and he addressed Parliament, not in the House of Commons, but in Westminster Hall, a very symbolic place, because years before, Thomas More, Chancellor of England, was on trial in that very room because he refused to recognize Henry VIII as the head of his church, the head of the church. He objected to it on religious liberty. He said, there's a higher law to which I must be true. He was sentenced to death in that very room. A very symbolic gesture that the Pope was invited to address Parliament in that very room. And he warned England, he warned us, as we become more secular and refuse to acknowledge God, then where do our rights and where does our dignity come from? And as a free, democratic, secular society, the only answer that we can give if we don't want to acknowledge God is that our rights and dignity come from the consent of the governed. In other words, the government. But when we do that, we fall right into the same message of totalitarianism, which said your dignity comes from the state. The founders of this country in the Declaration of Independence made it very clear. Our rights come from our Creator. And it would be at our peril as a country to forget that. But as we become increasingly secular, we will be under the impression that our rights and dignity come from the government. What the government can give, the government can take away. And that's the concern that I think is basic to this whole idea of religious liberty. Thank you.
On behalf of the Federal Society of Barney and Alex Howard Chapter, we'd like to give you this small token as our appreciation for you speaking with us this evening.
Thank you
very much. For those of you who'd like to get on our mailing list or would like to know when we're having our next meeting and who our next speaker will be, please see me before you leave. I'll give you my card and let you know. Generally, we meet the third Tuesday of every month from 5:30 till whenever we finish our topic. We're really lucky to have a great speaker on. I wish we had speakers like this every month, but we're hoping to have some other good speakers in the coming months. So get with me if you would, and I'll put you on our mailing list. Thank you all for coming.